All right, let's dive right into this explainer. Today, we're doing a deep dive, meticulously unpacking the absolutely massive, rapidly evolving landscape of India's data protection and privacy law. For the longest time, the digital rules of the road for the world's most populous nation were, well, they were kind of ambiguous, fragmented, and honestly pretty outdated. But that era, it's officially over. We're right in the middle of a colossal structural overhaul of how personal data is handled, governed, and protected in India. And when you actually stop and think about the scale of India's digital economy, we're talking over 800 million active internet users churning out mountains of data every single second. This overhaul is a huge deal globally. The stakes for multinational businesses and everyday folks are just incredibly high. Because of that immense scale, we're going to explore this architecture in serious depth today. To really wrap our heads around this dense legal shift, here's our roadmap for today. First, the constitutional foundation. Second, the anatomy of the DPDP Act. Third, the phased implementation timeline. And finally, enforcement and those heavy penalties. Section 1, the constitutional foundation. You know, the current legislation didn't just appear out of thin air, it was built on a very hard-won constitutional battle. You really can't understand India's current data laws without knowing the story of the K.S. Puttaswamy case. So picture this. Back in 2012, a retired judge, Justice K.S. Puttaswamy, challenges the mandatory biometric collection of the Aadhaar identity scheme. His argument? It violated fundamental privacy. But there was a massive legal roadblock in the way. Two much older Supreme Court decisions from way back in 1954 and 1962 were widely interpreted as saying, hey, the Indian Constitution doesn't explicitly protect a freestanding right to privacy. Now, in the Indian judicial system, a smaller bench of judges cannot overrule a larger one. So, because of the size of those older benches, they had to convene a massive 9-judge bench to settle the debate. This is an incredibly rare, totally historic event. And finally, on August 24, 2017, they delivered a unanimous ruling. They completely tossed out those decades-old precedents and firmly situated privacy as a fundamental right intrinsic to life and personal liberty. But look, simply declaring something a fundamental right isn't quite enough, right? You have to actually define its boundaries. So, to make sure the state doesn't just trample this right, the court built a super strict 3-part test. Any privacy-infringing action has to survive this test to be constitutionally valid. Number 1 is legality, meaning the state can't just act on a whim. There absolutely must be a specific law backing the action up. Number 2 is a legitimate state aim. The restriction has to serve a real, valid purpose. Think national security or preventing a crime. And number 3, proportionality. The government must use the least intrusive means necessary. To put that into perspective for you, let's say the government wants to track a specific criminal suspect. Proportionality means they can target that suspect's communications for sure, but they absolutely cannot surveil the entire neighborhood just to cast a wider net. That would be totally disproportionate. If a law fails even one of these 3 steps, boom, it's unconstitutional. Now, crucially, the court clarified something really important. The right to privacy is not an absolute right. It can be reasonably restricted. And this isn't just some dry piece of historical trivia. It's a foundational doctrine that is actively powering subordinate legislation today. Take November 2025, for example. The government amended a section of the Right to Information Act using the new data protection rules. To balance the public's right to information against an individual's right to privacy, they leaned directly on this exact proportionality reasoning from that 2017 judgment. So that foundation laid by the 9-judge bench, it's very much alive and actively shaping the rules in real time. All right, moving to Section 2, Anatomy of the DPDP Act. Let's see how that constitutional foundation translates into the actual legislative blueprint, the Digital Personal Data Protection Act of 2023. This act is India's first ever comprehensive cross-sectoral data protection statute. But to really navigate it, we need to meet the core actors. First up is the data fiduciary. This is any entity, a tech company, your bank, an online retailer that decides exactly why and how your personal data is processed. And notice they use the word fiduciary instead of controller. That's a very deliberate choice. It implies a legal duty of trust and care towards your data, which is a pretty powerful philosophical shift in the law. On the flip side, we have the data principle. Well, that's you. You are the individual the data belongs to. And what's super interesting here is that this massive act is notably the first Indian legislation to use she/her pronouns throughout its text to refer to you, which completely breaks away from the traditional he/him legal drafting conventions. Now, here is the real game changer. This act completely rewrites the rules of engagement for your data, especially when it comes to consent. Under Section 6, your consent has to check all these boxes. It must be free, specific, informed, unambiguous, and unconditional. What does that actually mean for you day to day? It means bundled consent is officially dead. Companies literally cannot force you to agree to unrelated tracking or marketing emails just so you can use their basic service anymore. You have to clearly opt in. And because that consent has to be unambiguous and unconditional, those sneaky pre-ticked checkboxes or deceptive dark patterns that trick you into consenting, strictly illegal now. Plus, taking your consent back has to be just as easy as giving it in the first place. You can't be forced to click through a maze of menus or sit on hold forever to revoke access that you gave with a single click.
So what happens when data crosses borders? Well, India deliberately pivoted to a much more permissive blacklist model, which really sets it apart from the European Union's super strict GDPR standards. See, the EU requires countries to be explicitly whitelisted through a formal adequacy decision before data can just flow there. India took the exact opposite route. Under the DPDP Act, data can flow anywhere in the world freely, except to specific countries that the Indian government explicitly blacklists. They chose this path mostly to foster startup growth and make doing business globally a lot easier. It basically keeps Indian companies from getting stuck in regulatory bottlenecks when they use foreign cloud servers or international SaaS platforms, as long as those servers aren't sitting in a restricted country, of course.
That being said, no data protection law is without its carve-outs, right? We have to impartially note that this act contains some pretty broad exemptions for government processing. If the processing is deemed necessary for state security, public order, or even just research and statistical purposes, those activities can sit largely outside the Act's obligations. Now, this design choice gets heavily criticized by legal academics. Their main concern is that these broad exemptions might potentially allow state agencies to act as massive data fiduciaries themselves, processing vast amounts of citizen data without any of the overarching accountability, transparency, or consent requirements that the private sector is forced to follow. It definitely remains a major structural tension point in the architecture of the law. Okay, let's jump to Section 3, the phased implementation timeline. Let's look at the reality of today and explore the actual moving-in process. So, the Act actually got presidential assent way back in August 2023, but then it kind of just sat inactive for over 2 years. Finally, after the rules dropped in November 2025, the government kicked off this complex 18-month phased rollout, which ends in May 2027. Phase 1 went live immediately in November 2025, laying out the definitions and setting up the administrative machinery for the new Data Protection Board. Then we have Phase 2, slated for November 2026, which activates the Consent Manager framework. If you're wondering what that is, think of a consent manager as a highly secure digital dashboard, or maybe a centralized app on your phone, where you can see every single company you've ever given your data to, and it lets you manage or revoke that access with one universal switch. Pretty cool, right? But it's not until Phase 3, in May 2027, that the real heavy lifting begins. That's when substantive compliance, like day-to-day notice requirements and full breach notification duties, actually lock into place. Looking at that incredibly staggered timeline, you're probably asking yourself a very practical question. Where do we stand today? Right now, while we wait for Phase 3 to arrive, what rules are actually protecting our data? Well, the answer requires a little bit of legal juggling. Until we cross that May 2027 finish line, India is operating in a genuine, complicated transitional overlap, where the old framework is basically holding the line. Specifically, the old regime under Section 43A of the Information Technology Act, along with the 2011 Sensitive Personal Data or Information, or SPDI rules, technically remains in full force. Those 2011 SPDI rules cover sensitive things like your passwords, financial info, medical records. But to be honest, they've historically been notoriously weakly enforced compared to what the incoming DPDP Act promises. So right now, companies are desperately trying to bridge the gap. They're having to comply with these legacy 2011 rules while simultaneously scrambling to build the massive IT infrastructure they'll need for the strict 2027 DPDP enforcement. And that brings us to Section 4. Enforcement and heavy penalties. Let's examine the trapdoors of this new legal architecture, which is governed by the newly established, fully digital-first Data Protection Board of India. Let me tell you, when these rules fully bite, they bite hard. Look at this staggering number, 250 crore rupees. To put that into perspective, that's roughly 30 million US dollars. That is the maximum penalty per violation just for failing to implement reasonable security safeguards. And here's the kicker. These penalties can stack. Let's run through a rapid-fire hypothetical. Imagine a hospital network gets hacked. If they failed to secure their servers properly, boom, 250 crore maximum fine. But if they also failed to immediately alert the board about the breach, that is another massive fine stacked right on top of the first one. The compounding math here is deliberately designed to terrify companies into taking compliance seriously. It creates potentially ruinous financial consequences for any negligence. The financial stakes are just astronomically high across the board. Beyond the 250 crore for security failures, these fiduciaries face up to 200 crore rupees for consent violations, for failing to notify the board of a breach, or for mishandling children's data. Now, knowing there would be inevitable pushback against these massive fines, the government made a highly strategic choice. They decided not to create a brand new tribunal for appeals. Instead, any appeals coming from the Data Protection Board are routed directly to the existing Telecom Dispute Settlement and Appellate Tribunal, or TDSAT. This matters immensely. Why? Because it means these appeals go straight to a tribunal that's already deeply experienced in handling massive corporate telecom disputes, rather than a brand new, totally untested judicial body that might take years just to figure out its own administrative paperwork. And this brings us to a massively critical operational detail that is deeply unique to the Indian framework. Unlike the GDPR in Europe, on a strict reading of the rules, the DPDP Act imposes absolutely zero materiality or harm threshold for breach notifications. None. This means that absolutely any personal data breach, no matter how tiny or trivial, technically must be formally reported to the board. Think about what that means in your daily operations. If a bank employee accidentally CCs instead of BCCs an email newsletter, exposing a few client email addresses, breach. Or if an HR manager leaves a printed employee roster sitting on a public desk in the lobby, breach. Even if these slip-ups cause literally zero financial harm to the data principal, under a strict reading, they trigger a mandatory federal reporting requirement. So, as Phase 3 approaches and full enforcement looms on the horizon, this structural choice leaves us with one vital overarching question. Will this meticulous new law create an impenetrable fortress for user privacy, ensuring absolute accountability at every level? Or are we just looking at an administrative nightmare of endless paperwork where actual harmful cyber attacks get completely lost in a massive haystack of trivial everyday alerts? It is a fascinating experiment in regulatory scale, and balancing that theory against actual operational reality is going to be the ultimate test of India's new data regime. Thanks so much for joining me on this deep dive.